Hi, I'm David Fraser. I'm an internet and privacy lawyer with the Canadian law firm McGinnis Cooper. I also teach internet and media law at the Schulich School of Law at Dalhousie University. Some friends on social media just made me aware of a situation in the province of Quebec where an individual has been charged under a municipal bylaw for insulting politicians and public servants on social media. This seems completely bonkers and a complete affront to freedom of expression, so I had to look into it, and I thought I would share my thoughts with you. It's also a good example of how the Canadian Charter of Rights and Freedoms works in practice. So it appears that the municipality of Chelsea in the province of Quebec has a bylaw related to peace and good order, or something like that. The bylaw contains a whole lot of the usual things you'd expect, like smoking and drinking in parks, loud cars, and things like that. But it has this extremely bizarre provision that makes it an offense to insult a municipal public servant. Here's what it says, 7.23. It is prohibited by any mode of communication, particularly on social media, for any person to insult a peace officer, a municipal elected official, a municipal official, or a municipal employee. It appears that this would be the provision that the individual has been charged under. I don't think this is a valid law and should be struck down the moment it is considered inside a courtroom as being in violation of Section 2B of the Charter of Rights and Freedoms. There's probably also a valid question as to whether a municipality has even the basic jurisdiction to enact something like this, but I'll set that aside to focus on the Canadian Charter. I expect it would also be equally invalid under the Quebec Charter, but again, I'm going to focus on the Canadian Charter of Rights and Freedoms in this discussion. So the Canadian Charter is a part of our Constitution, which says that any law that is incompatible with the provisions of the Constitution, including the Charter, is invalid. Here's what it says under the primacy of the Constitution of Canada. The Constitution of Canada is the supreme law of Canada, and any law that is inconsistent with the provisions of the Constitution is, to the extent of the inconsistency, of no force or effect. Essentially, unless you invoke the notwithstanding clause, every law, regulation, and bylaw has to fit within the guardrails set by the Constitution, including the Charter. One of our most important rights articulated in the Charter is the right to freedom of expression. It says everyone has the following fundamental freedoms: freedom of thought, belief, opinion, and expression, including freedom of the press and other media of communication. Now, these charter rights are not absolute, as they're subject to Section 1 that allows a limitation on a charter right where it can be justified. So Section 1 says the Canadian Charter of Rights and Freedoms guarantees the rights and freedoms set out in it subject only to such reasonable limits prescribed by law as can be demonstrably justified in a free and democratic society. The best example of a similar case that could be used as an example for this one, where a law related to online expression was struck down as being a violation of the Charter, is the case of Crouch and Snell. This is a case that I took to the Supreme Court of Nova Scotia to challenge the constitutionality of the Nova Scotia cyberbullying law that existed at the time. I called that law a dumpster fire, but the judge ultimately referred to it as a colossal failure. That law created civil remedies, which could include an absolute gag order, if you were to simply hurt somebody's feelings online. It didn't matter whether what you were saying was absolutely true, or in the public interest, or whether it was said without any malice. All of that would fit within the definition of cyberbullying. In the case of the Chelsea bylaw, all that matters is that the person is insulted. The bylaw does not take into account whether or not the insult is deserved, whether the insult is true, or whether the insult is ultimately in the public interest. There is nothing in the bylaw itself related to trying to satisfy the requirements of Section 1 of the Charter, trying to make it a reasonable limitation in any circumstance. The Chelsea bylaw is even worse in that it is creating an offense that can be prosecuted by the state rather than a private right of action. The Nova Scotia cyberbullying case took place during an election, so I was able to use real-time examples of political insults that were being hurled in connection with that federal campaign. So let's talk about the mechanics of these sorts of things. The municipality of Chelsea never should have passed this bill in the first place, but there isn't an obligation for legislators or municipalities to ensure that the laws and bylaws that they pass are compatible with the Charter. Of course, they absolutely should do that, but they apparently did not in this case. Now, maybe their plan was actually to chill free expression until somebody had the resources to have it struck down. So the law's on the books, and the cops are apparently more than happy to enforce it until it's struck down. And even once it's struck down, the words still remain in the bylaw and will continue to have a chilling effect. In my view, legislators should be required to repeal statutory provisions that have been found to be unconstitutional. Otherwise, you end up with all these phantom laws, which are of no force in effect, many of which still exist, for example, in our criminal code. What generally happens is that somebody will be charged under a law or bylaw like this, and will respond to the charge by stating that they first did not do it, but even if they did, the provision is unconstitutional and the whole thing should be thrown out. The court will generally first look at whether or not the charges or the offense has been made out, because they tend not to do the charter analysis unless they really have to. In this case, assuming the reporting is correct, I'm confident there were insults. Local media say that the accused called municipal politicians and staffers fart catchers, devil excrement worshippers, little fascists, and idiots. Those sound pretty insulting to me. In the charter challenge, the burden is on the accused to simply point out and demonstrate with a relatively low threshold that the provision infringes their freedom of expression. At this stage, it would not be uncommon for the Crown to make the absolutely absurd argument that an insult is not charter-protected speech. It absolutely is. Based on the case law, there really can be no doubt, and I don't know why Crown lawyers continue to waste court time on trying to find exclusions from what is charter-protected speech. The Supreme Court of Canada has clearly said that anything that expresses meaning short of a punch in the face is charter-protected expression. This happened in Crouch and Snell, where the Crown lawyers tried to argue that cyberbullying was so low value that it didn't meet the threshold of being protected expression. They were wrong. The court threw that argument out. The court said, with respect, I find this approach, which confines the analysis to only the expression at issue in this case, to be too narrow. I must consider all the types of expression captured by the Act. The Act restricts, quote, any electronic communication through the use of technology that is intended or ought reasonably be expected to cause fear, intimidation, humiliation, distress, or other damage or harm to another person's health, emotional well-being, self-esteem, or reputation, and includes assisting or encouraging such communication in any way. The court went on to say it's not difficult to come up with examples of expressive activity that falls within this definition, and at the same time promotes one of the core freedom of expression values. The court then quoted from a case called Self, where Justice Moyer said at paragraph 25, quote, a neighbor who calls to warn that smoke is coming from your upstairs windows causes fear. A lawyer who sends a demand letter by fax or email causes intimidation. I expect Bob Dylan caused humiliation to P.F. Sloan when he released Positively 4th Street, just as a local online newspaper causes humiliation when it reports that someone has been charged with a vile offense. Each is a cyberbully, according to the literal meaning of the definitions, no matter how good the intentions of the neighbor, the just demands of the lawyer, or the truthfulness of Mr. Dylan or the newspaper. So the court said, in conclusion, I find that the Act has both the purpose and the effect of controlling or restricting freedom of expression. In the case of the Chelsea bylaw, the bylaw covers insults. Surely calling a corrupt politician corrupt is an insult. Calling a lazy person lazy is an insult. But that's part of politics. So once the accused has shown that there is some infringement of a charter right, the onus flips to the Crown to justify that infringement under Section 1 using something called the Oakes test. To be justified under the Oakes test, a limit on a charter guaranteed right has to be prescribed by law. It has to be a reasonable limitation, which requires the Crown proving that the legislative goal is pressing and substantial, and that the limitation is proportional. This requires the Crown to prove that there is a rational connection between what the legislator is trying to achieve and the means chosen to achieve it. Then the Crown has to prove that the right is minimally impaired, so there is no other less impairing way to achieve the objective, and then there's a final balancing. In the Crouch and Snell case, the Nova Scotia cyberbullying law was found to have a pressing and substantial objective, but was not rationally connected because it was not specifically targeted. The Nova Scotia law was not minimally impairing and did not pass the final balancing test. The court said, and I quote, it is clear that many types of expression that go to the core of freedom of expression values might be caught in the definition of cyberbullying. These deleterious effects have not been outweighed by the presumed salutary effects. If I were to look into a crystal ball, I would say that the Chelsea bylaw is not only prima facie an infringement of charter-protected expression, I would say that it cannot be justified under Section 1. It is prescribed by law, and the objective of protecting against unwanted and unwarranted harassment may be pressing and substantial, But the means chosen by the municipality go so far out of bounds that it can't be said to be rationally connected to that objective. There's no doubt in my mind that it's not minimally impairing because there's no defense of truth, fair comment, or other justification. And finally, it'll fail on the balancing test. And remember, if it fails any of these, it'll be struck down. And at the end of the day, I think the municipality of Chelsea should be embarrassed for having passed such a bylaw in the first place. I hope this has been interesting and useful. I try to put out a new video each week or so, or every few weeks. So if you're interested in this sort of content, please click the like and subscribe buttons. Also, leave a comment if you have any questions or you have suggestions for any other topics to cover. And of course, feel free to share this with anyone who you think may be interested in hearing about developments in Canadian tech and privacy law. Thanks for tuning in.